So we'll introduce ourselves, and then you can introduce yourself. I'll read the question, and we'll get started, okay? So I'm Cristiano Olivo. I'm a political science professor at University of Northern Colorado.
I'm Jeff Wells. I'm the city attorney in Fort Lauderdale, Colorado.
And I'm Paul Schauer, former state representative, former board member, Board of Regents, University of Colorado, and I come out of the corporate world.
My name is Samir Harden, I'm a senior.
My name is J.R. Smith, and I'm a senior.
My name is Grayson Amel, I'm also a senior.
Great, and is your teacher here?
Yeah, our teacher is Mr. Jeff
Hi.
Hi, nice to see you. Okay, so the question we've chosen for you today is question number 2. Why did the founders believe that a constitution should function as a type of higher law? In what important ways does a higher law differ from a statute enacted by a legislature? Evaluate the founders' claim that direct democracy was more likely to ignore constitutional limits than representative government. What evidence, historical and contemporary, can you offer in support of your position? And you may begin.
The English government's dictatorial treatment of the colonies included taxing them without representation, as seen in the Tea Act, the Stamp Act, and the Township duties, eliminating the right to trial by jury and illegally seizing property to house English troops under the Quartering Act.
When the framers drafted the Constitution, they wanted to prevent further government abuse. Thus, they established the Constitution as a higher law. And in order to preserve this status, amending the Constitution is significantly more difficult than enacting a statute. For 2/3 of all members in both houses are needed to propose, and 3/4 of all state conventions or legislatures are needed to ratify, as provided in Article 5, while only a bare majority is necessary to enact a statute, as provided in Article 1, Section 7.
James Madison wrote in Federalist 10 that majority rule enables it to sacrifice to its ruling passion or interests both the public good and the rights of other citizens. The framers of the Constitution realized that without a guide for legislation in the form of a higher law, legislatures can and often do ignore the rights of minority factions.
Alexander Hamilton wrote in Federalist 78 that constitutional limitations of this kind can be preserved in no other practice than through the medium of courts of justice. The Constitution provides in Article 3 that judges shall serve for life and that their wages shall not be reduced. These two provisions ensure that the judiciary can examine statutes to test their constitutionality independent of popular will. There is no shortage of cases in which the Supreme Court has done so.
Thus, in again the United States, the Supreme Court ruled against grandfather clauses that marginalized African American voters in the South, saying that they were repugnant to the 15th Amendment and therefore null and void.
In Brown v. Board of Education, the Supreme Court ruled that state statutes that segregated schools were unconstitutional because they did not provide with equal educational opportunities assured in the 14th Amendment.
And just last year, the Supreme Court ruled in United States v. Windsor against the Defense of Marriage Act, enacted by Congress to only recognize heterosexual marriages. Justice Anthony Kennedy wrote in the majority opinion that because the federal government is treating those persons as living in marriages less respected than others, the federal statute is in violation of the Fifth Amendment.
While representative government can and often does ignore constitutional limitations, direct democracy is more likely to do so. The framers feared that direct democracy uninhibited would imperil the rights of the minority faction. As Benjamin Franklin put it, democracy is 2 wolves and a lamb voting on what to have for lunch.
The most violent example of direct democracy in United States history is the Kansas-Nebraska Acts, which provided that the issue of slavery would be decided by a direct vote of citizens of the Kansas and Nebraska territories. Horace Greeley wrote, "We are not one people, we are two people. We are people for freedom and a people for slavery. Between the two, conflict is inevitable." Direct democracy devolved into the carnage of bleeding Kansas and the deaths of hundreds of Americans.
While less violent, modern direct democracy still infringes on minority rights. In 1994, Amendment 2 was a ballot initiative proposed to the Colorado Constitution. For the Colorado Constitution provides that the people reserve to themselves the power to propose new laws and amendments to the Constitution. Amendment 2 would have made illegal any gay rights laws by preventing any laws that protected homosexuals as a minority class.
In Romer v. Evans, the Supreme Court ruled that the amendment's sheer breadth is so discontinuous for the reasons offered for it that it seems inexplicable by anything but animus towards the class it affects. It lacks a rational relationship to legitimate state interests. A higher law is necessary because statutes enacted by a legislature or direct democracy are naturally tied to the passions of the majority, which often infringe on minority rights. We are now ready for your questions.
Okay, great. So interesting that you mentioned Amendment 2 in that case. So we have a lot of direct democracy going on in our state still today. Do you agree with this, that this is not a good thing, or what's your opinion about direct democracy today in our state?
Well, Colorado has it's interesting as compared to the US Constitution that that amendments to the Colorado Constitution only need a 51% majority to be enacted, as opposed to the supermajority necessary to the actual Constitution. But in order to, my apologies, in order to protect the rights of minorities, and in order to make sure that the people are protected and listened to in the Constitution, the Colorado Constitution ensures that, like through the Tabor Amendment, that the people are listened to.
And this Tabor Amendment also has played out to be somewhat negative depending on somebody's views. As early on in the school year, the citizens of Colorado voted against a tax bill that would increase revenue to the schools, therefore making just the educational atmosphere of students in Colorado a whole lot more beneficial, and that by direct democracy that was voted down by the citizens of Colorado.
Direct democracy necessarily necessarily focuses on the majority, and we would not want a situation to occur as seen recently in Egypt, as they're using a referendum, which is a form of direct democracy, to vote on their constitution, and this has caused a lot of chaos and conflict between the government and then the minority class, which is the Muslim Brotherhood.
How has the establishment of term limits in the state of Colorado or throughout the United States and various states affected representative government, and is it a good thing or a bad thing?
Term limits ensure that even as politicians stay in power for a long time, they tend to be more and more removed from the people. And so term limits ensure that the people are constantly feel in touch with their politicians, and the politicians feel are responsive to the needs of the people. And so it ensures that the rights, that the beliefs of the people are represented properly.
This is advocated most famously by Newt Gingrich, how, ironically though, he has served a large number of years in the United States Senate. But he does argue that term limits, like Grayson said, would make the senators and the other politicians in office more responsive to the people's needs and direct and not propose their own agendas. They would propose the agendas of the people that they are representing.
But do you believe it takes away from the people's right to vote on who they want to represent them?
I do not believe it takes away from the people's right to vote on who they want. Actually, I'm just gonna stop.
For a politician to stay in power for a long time, the people simply will vote for another person with kind of the same ideals as a thing. Just because one person is removed from the political system does not necessarily mean that their ideals are removed from the system, and that people will make sure that their beliefs are heard through whoever they decide to vote into office.
Let me go to another subject, and that is the advantages and disadvantages of a written constitution or an unwritten constitution.
Well, constitutionalism itself is the idea that the government be legally limited by set policies. And so I don't believe that a written constitution is necessary for constitutionalism to be present, as seen in the United Kingdom, where they don't have a written constitution because they haven't really had a revolution where they just had to have a set ideas instilled immediately. However, constitutionalism is present, as in 2005 they had a Constitutional Reform Act where they separated some judicial powers from the legislative branch and put those judicial powers into a separate judiciary branch, showing the limitations on the legislative branch and an increase in judicial powers.
And in 2009 in the United Kingdom, a Supreme Court was officially enacted, which in fact replaced the House of Lords Appellate Committee, and now provides a check on the House of Commons, which is in charge of creating the laws in England. And this is not this is not specified in the Magna Carta. It's written in 1215. However, they have no written constitution. However, constitutionalism is being actively practiced in the United Kingdom.
And it's also worth noting that constitutionalism, having a written constitution does not necessarily lead to constitutionalism. Just a few weeks ago, Thailand enacted a state of emergency law, sea martial law, that the prime minister enacted in order to stop protests. But Thailand has a written constitution that protects the right to protest. And so just having a constitution say that the right to protest is necessary is a standard right of the people is not necessarily going to protect that right. And so constitutionalism is the idea that the Constitution will be followed if it is even written.
Let me go spell a little bit. What about the Founding Fathers? Why did they think we needed a written constitution? It's great, these out-of-country examples, but
Well, the founding
bring it here.
fathers believed we needed a written constitution because what spurred our split from England was the fact that we were citizens of the United Kingdom and we weren't given rights, and therefore we wanted to specify our rights now as American citizens under the Constitution.
In Federalist Papers 51, Pugliese wrote that if angels were to govern, then there would not need to be restrictions on there would not need to be restrictions on laws and power.
Okay, good, thank you. So now for some feedback. I really liked overall your initial opening statement. I just love that you brought so many concrete examples in, historical, contemporary, and also the examples you brought in question and answer period. Those were really good. I was just wanted to get back, but we always run out of time in question time. But back to your ideas, I think you could maybe think through a little bit more the direct democracy issue, because it seemed to me, if I understood you correctly, that what you were saying was a little contradictory. So on the one hand, that you don't really trust direct democracy and you agree with the founders and representative government, but then on the other hand, to the question of term limits, then you said, well, yes, the people have more say, right? And then you mentioned Tabor, and it seemed like you were sort of in favor of Tabor, like it was a good thing, if I understood correctly. So it was a little muddled for me, and it's not necessarily bad to have different opinions about something, but it was a little confusing to me. So that just might be one thing to think about in answering. But overall, like I said, I thought you did a great job, and I really appreciated all the different examples you brought in.
Sure. Well, first of all, I think you did a really good job with your presentation. I really liked some of the examples. The quote from Benjamin Franklin was great. I really liked how you put that together. Sam, I think one of the things that you did very well is when you realized that your argument isn't the best argument, you conceded it and said, you know what, I don't think I'm going to go any further on that. And, you know, that's a smart thing to do, because I think this is a learning process, and I was really happy to see that all of you are thinking about your answers, and I agree with Christiana that one of the things you want to do is think through on all of these different perspectives on representative versus direct democracy. You know, you brought up the Amendment 66 issue and how we were trying to get money for schools. You know, if you look at what Aristotle's concerns were with regard to direct democracy, it was a concern that the majority would then pilfer the rich minority and create problems, and ultimately that was one of the concerns that they had. Is that a similar situation that we see with direct democracy in Colorado in Amendment 66, that the majority can then determine through an income tax that people are going to pay for schools? And so I think there's some, if you look historically in the political philosophy, you're going to see some examples that are completely relevant today on policy issues that are being taken up through direct democracy that may have good or bad consequences. As to the issue of term limits, you know, there's that question: are we taking away the right of the people to vote on who they want to vote on to represent them when we do term limits? And are we limiting the knowledge and experience of people within the legislature that might be able to be in a better position through their understanding to make better decisions for us? I mean, that's one side of that argument that is rarely discussed, because it's now the law that we have term limits. But I thought and really appreciated all of your answers, your presentation. I thought you did a very good job.
Yeah, I thought it was a great presentation, and you did read the Federalist Papers, and the issue of term limits having been mentioned, go back and read in the, I think it's 34, 35, 36, 37, where it does talk about term limits, and the original Continental Congress did have them. but it does really limit people's ability to vote for who they want to represent them. I thought your examples were great, the Supreme Court references, the higher law, Tabor. Remember, it didn't pass unanimously, it passed by less than, what, 2%. So, part of the people didn't get their say, yet it was written in such a way that it actually limits the ability of people to respond to their needs, to their representatives. Like I said, I thought you had good examples. I think that's one of the keys. And your eye contact was good, obviously. Your preparation on the whole effort was, your opening statement was good. And your use of quotations, always good, historical quotations. So,
Thank you.
good job.